Hello, everybody. This is Samantha from the law offices of Samantha Wolfe, and we're here today for our monthly virtual seminar. It's a continuation. We're trying to focus on different estate planning documents. So thank you so much for joining us. Wanted to welcome you. For those of you who aren't aware, we do monthly seminars every month, and then we record them and post them on our YouTube channel so everybody can enjoy them. So let's go ahead and jump into today. So we're going to go ahead and share our screen and get started today. This is a picture of the front of our office. 20 East 6th Street, Suite 206 in Waynesboro. We do offer initial consultations. Our number is 717-655-2676. We do all of these monthly virtual seminars as part of our mission statement because we do feel like it's part of our job to make sure clients, referral sources, those in the community are educated and aware of different estate planning options that they have. Today, we're continuing our series where we're doing song titles. So we're talking about Knocking on Heaven's Door, Last Will and Testament, Probate, and Non-Probate. So the last couple we focused on financial power of attorneys, then we did healthcare power of attorneys. So today we're going to focus on the last will and testament. So starting off, just a refresher for a lot of you who already have your wills in place. A last will and testament is just written instructions about how you want your property to be distributed when you pass away. The designation of an executor, or we actually refer to them as a personal representative in our documents, that's who's going to administer your estate upon your death. So that's who has the fun task of making sure all your stuff gets distributed the way you have in your will. It does allow you to designate a guardian for minor children, and it does allow you to name a custodian if any beneficiaries are underage. And in Pennsylvania, you can name a custodian all the way up to age 25. So you don't have to do a trust in Pennsylvania if you would have underage beneficiaries. We're going to talk about probate versus non-probate, but just so you know, any assets that pass through the will are considered probate assets. There are non-probate assets. Non-probate assets are those assets that pass outside of the will, meaning that maybe you had a beneficiary designation, maybe you had a joint owner. Those would be reasons that it would be a non-probate asset. So just know that when people throw around the term probate, they're just talking about the process by which your assets are distributed according to your will. And they do have to go through a formal court process where they're appointed as the executor. Then the Register of Wills issues what they call a short certificate. That's the paperwork that gives the legal designation that you can serve as the executor. The will should also have instructions about tax payments or tax apportionment, because Pennsylvania is one of only, I think, 5 states that have an inheritance tax. So one of the things the will needs to address is, how does that tax get paid? Meaning, does the general estate pay it? Meaning that before any distributions go out to any beneficiaries, it's paid out, the tax is paid out from the estate, and then anything left over is distributed out to the beneficiaries. That would be one way to do it. The other way to do it is you might say that the tax is apportioned to a specific bequest or to the non-probate assets. So for example, let's just say, and I'm going to use my family as an example, for those of you that have been listening, you do know that of course I'm my parents' favorite child. So let's just use that as an example. So I'm the favorite child, and my dad decides that in his will, he's going to have everything divided among my sisters and I, but he's going to designate me as the beneficiary of his retirement policy because I'm his favorite. So in his will, if he says that the tax is apportioned to the residue of the will, the issue there is that my sisters are actually paying the inheritance tax on my retirement assets. So I got the benefit of this large retirement account, plus my sisters get the pleasure of paying the inheritance tax on this retirement account. So although most people have tax apportioned to the residue, if you're going to have different beneficiaries of retirement, life insurance, any non-probate asset, you want to make sure that your will is properly addressing that, whether it be that it's paying from the residue or whether you're going to allocate it to each specific asset. So I know this isn't going to surprise some of you who are listening, but I did an entire presentation to attorneys talking about tax apportionment. And not surprisingly, I talked for probably an hour and a half about it. So that just goes to show you I can talk pretty much about anything when it comes to estate planning. So the other thing I wanted to talk about that we're running into more and more is the last man standing when we're talking about spouses. So, for example, let's say my mom and dad come in to meet with me and they want to set up their wills. And my mom says, well, I want my assets to be distributed equally between my 4 kids. But my dad says, well, no, Sam's my favorite. So I'm going to have her get 50%. And then the other 50% of the estate gets divided among the 4 kids. So what happens there is if my mom dies first and all of the assets are jointly owned between my parents, meaning that mom and dad's name are both on the title, then all assets go to my dad, and his will is going to be the one that actually distributes the assets. So in that case, if my mom dies first, I'm going to end up with 50% of the estate, plus I'm going to end up with another 25% of that remaining 50%. Where if my dad dies first, I'm just getting 25% because my mom split everything equally between my sisters and I. So I try to explain to married couples that you really want mirror image wills, meaning that they're going to look very similar. The only difference is you're going to be appointing each other and distributing it to each other, and then you're going to be distributing it how you want. And then that way, it doesn't matter who dies first. The estate is being distributed the way that you wanted it to be distributed. So surprisingly, I review a lot of wills where the previous attorney might not have accounted for that. And so when I talk to the couple about, well, if you die first, it's going to go this way, but if husband dies first, it's going to go the other way, then they're always a little shocked by that. So I want to make sure that clients understand that we do typically have mirror image wills for husband and wife. But I did have a client earlier this week who wanted to create a joint will, and I've been practicing law since 2008, I believe, and I've never seen a joint will. You just don't do them in Pennsylvania. The reason that you don't is that you each need to have an individual will, because what happens if somebody gets remarried or the provisions change? You need to make sure that you can adjust your own will accordingly. So I wanted to make sure to talk about that. Okay, let's talk about what happens if there's not a will. I love talking about this topic because it's always shocking to people to realize that Pennsylvania imposes their own estate plan if you don't have one. And most of the time, people don't like the estate plan that Pennsylvania is going to put on your assets. So let's talk about what Pennsylvania intestate law says. So intestate law is Pennsylvania has a statute that's going to dictate how your estate is distributed if you don't have a will. And 9 times out of 10, when I talk to couples that don't have a will, they don't actually want their estate to be distributed according to intestate law. So these are the rules for intestate in Pennsylvania. So if you have a surviving spouse and there's no issue or parent living, then 100% goes to your surviving spouse. If, however, you have issue, meaning children, or a parent that is surviving, then the first $30,000 goes to the spouse plus 1/2 of the estate. The other half goes, for example, to the issue. So let me give you an example of this, because until you actually think about it, I think you don't really recognize how bad this might be. So let's take my parents. My parents have been married for 40 plus years, so a long-standing marriage. And if my dad and mom did not have a will and my dad died, my mom would get $30,000 off the top, plus she would get 1/2 of the estate. My sisters and I would actually get the other 1/2 of that estate. So again, my parents probably want it to go to each other. They probably like each other enough that they would want their estate to pay to each other first. But unless you have a will, it's going to get divided among issue. And issue is just another way of saying children, grandchildren, kind of down the line. So if you don't have a will, and you are married and you want it to go 100% to your spouse, but you have children, just know that Pennsylvania's estate plan for your assets is not going to be everything going to your spouse. Now, if you don't have a spouse, but you have issue, then it goes 100% to your children, grandchildren. If you have no issue, then it does go to your parents. If you have no parents, then it goes out to your siblings. So for example, right now, if I would pass away without a will, my parents are living, I don't have children, I don't have a spouse, so it would actually go 100% to mom and dad. If I would have a spouse, then that would be a different situation. So you just have to think through what the intestate rules are for your situation. And again, if you don't like Pennsylvania's estate plan, you can always do your own will, and then you don't have to worry about that. So here's an example of John and Jane Doe. So they're married, they have one child. Jane dies and she didn't have a will. So what happens is John gets $30,000 plus one half of the estate, and the child gets the other half of the estate. Now, what if John and Jane are married and Jane was married previously and that child was actually with her first husband? If she dies and she doesn't have a will, what does Pennsylvania say? So Pennsylvania is going to say, well, John's not going to get the first 30,000. Instead, he's just going to get one half of the estate and the child's going to get the other half of the estate. So he lost out on that 30,000. Again, if you don't like this, then just make sure that you have a will in place. Then you don't have to worry about it. So let's talk about ways to protect against intestate succession. So again, intestate succession is Pennsylvania's estate plan for you if you don't have a will. So the first thing you can do is have a will. And a will is not that expensive. Typically, it's a couple $100s to do a will, and it can save a lot of time, trouble, hassle, expense for your beneficiaries and for your executor. Another way you can protect against an intestate estate succession is to have a joint ownership. So anything that's owned between spouses jointly, for example, when one spouse dies, it goes to the surviving spouse. That counts for real estate, that counts for bank accounts. You can also have a non-spouse joint owner. So let's just say that I wanted to buy a piece of property with my sister. We put both of our names on it. You can own it joint with right of survivorship. So that would mean if I died, she gets my 50%. If she dies, I get her 50%, and it doesn't go through the will at all. So you can do that with joint ownership. Now in Pennsylvania, unless you use the special language joint with right of survivorship for a non-spouse joint owner, then the default in Pennsylvania would be that we own it 50-50, and if I died, my 50% would go according to my will or my estate plan, and my sister's 50% would go according to her will or her estate plan. You have to make sure that the deed actually says joint tenants with right of survivorship. And I did just recently deal with an estate where I think the client thought that it was joint tenants with right of survivorship, but he passed away and his joint owner didn't automatically get that 50% because the deed was silent on it. So it's not just that you have to use special language, you have to make sure that you address it in some way, because if you don't put any direction about how you own it, then the default in Pennsylvania is that each owner owns their respective percentages, and it then goes according to their estate plan. Another way to avoid intestate succession is through beneficiary designation. So that would be a retirement, a life insurance policy, anything where you're able to name a beneficiary. I always tell clients they want to have a primary and at least one contingent. But typically I encourage you to have a primary, a contingent, and then what they call a tertiary beneficiary or a second contingent beneficiary, just in case. And then the last way that you can avoid intestate succession is to have a pay on death or a POD, or a transfer on death, which is a TOD. So it acts as a beneficiary designation. It's just that certain financial institutions for certain assets, they don't call it a beneficiary designation. They call it a transfer on death or a pay on death. And I think a good way to handle this is if you have an account, always ask if you can designate a beneficiary so that way we're avoiding intestate and we're avoiding the probate process. So what is a probate estate? So like we talked about, the will allows your assets to be distributed how you've designated in the will, but probate is the process by which the executor is actually able to distribute the assets. So to the extent we can limit or completely eliminate the probate estate, it always means less cost and less time. So I always tell clients when they're asking, why would I want to avoid probate? The number one reason would be attorney's fees. Attorneys typically, to probate an estate, you're talking about, to do all those different things to probate, usually about $5,000 right off the bat when you have to probate. So if you can avoid probate, you would be reducing attorney's fees quite significantly. The other reason you avoid probate is because it just takes time. Typically, an estate going through probate is going to take about a year for everything to get distributed and divided the way it should be. If you do it through a beneficiary designation or through a trust, the benefit there is it doesn't take as long. We can distribute those assets quicker. So what is a probate estate? It's assets that don't have a beneficiary designation, that don't have a joint owner, that don't have a transfer on death or a pay on death designation, and that are not owned in a trust, because people can do a trust, and if the assets are owned in the trust when they die, that does avoid probate as well. But you don't have to go to the extent of doing a trust. If you can throw a designation, beneficiary designation on it, then that would avoid probate. So other administration that you can do is trust administration. Like I said, if you do have a trust and the assets are owned in trust when you die, it does avoid probate. One of the most obnoxious things that clients have to deal with is if they have an attorney that does a trust but doesn't fund it. And we do have a lot of clients, they usually come in and they have like a binder and it's a revocable trust. And for whatever reason, they were in charge of funding it. The attorney didn't help them and they never went back and retitled assets. And if that's the case, if you have a trust that's unfunded, then it still goes through probate. You didn't get any advantage of that trust. So when you're talking about a trust, it's not just having the trust in place, it's making sure that the stuff you want in trust is actually transferred into the trust. And then beneficiary designations. The thing I wanted to mention here is that Pennsylvania still does have an inheritance tax. So even though there's not really administration for a beneficiary designation, just know that that does not mean that there's not going to be an inheritance tax. It just means that you avoided probate. So non-probate assets, items that transfer directly to the designated beneficiary without going through the will, jointly owned property with rights of survivorship, retirement accounts, trusts, bank accounts, and certificates of deposit. So it used to be that if you had a checking or a savings account, you couldn't designate a beneficiary, but more and more banks and financial institutions are allowing you to designate a beneficiary. Now, the one caveat to all of this that I will say is that when you designate beneficiaries, just remember that there's not going to be money in the estate. So if there is real estate where there's going to be taxes, expenses, utilities that are going to have to be paid during the administrative phase, you just want to make sure that either there's enough liquidity in the estate to pay for that, or you want to make sure that the beneficiaries know that they may have to be paying some of those expenses during the administrative phase. Because otherwise, when we're dealing with an estate where there are a whole bunch of beneficiaries, you have to run around and get them to contribute money to help pay the expenses on real estate. So if we're going to have a lot of beneficiaries, or maybe we're going to have real estate that's going to take us a while to sell, we want to make sure that we have enough liquidity in the estate. And that's why sometimes attorneys don't designate, or they'll say, we don't recommend you designate beneficiaries. I do, because number one, it avoids a Medicaid recovery lien. So if you die in a nursing home and assets go through your will, then the nursing home can attach to those assets, where if it's through a beneficiary designation, they cannot attach when you pass away. So that's one of the reasons why. And then finally, life insurance policies, because you can designate a beneficiary that's a non-probate asset. So dates to remember, well, honestly, if you've kicked the bucket, you don't have to remember these dates, but your beneficiaries will. So know that the Pennsylvania inheritance tax return is due within 9 months of someone passing away. However, if you pay the tax within 3 months of death, you do get a 5% discount on the tax that's owed. So in our office, we're trying to make sure that we account for assets, estimate as closely as we can, and go ahead and prepay it within 3 months so we can get that discount, especially if it's going to be a beneficiary that's not a direct lineal descendant, because based on your relationship to the decedent determines your rate of tax. So in Pennsylvania, you're either at 0% if you're a spouse, 4.5% if you're a direct lineal descendant or ancestor, 12% to a sibling, and 15% to nieces and nephews. 1 year from the date of the first advertisement, creditors are barred. So one of the things that you do is, as part of the probate process, is you have to advertise in a paper of general circulation and then in a legal journal. You have to do that once a week for 3 consecutive weeks. Once you've done that, though, once in the legal journal and once in the paper of general circulation, it's considered a complete advertisement, and 1 year from that date, no creditors can come forward. We mentioned this before. There's a difference between avoiding probate and Pennsylvania inheritance tax. So just because you don't have to probate doesn't mean there's no Pennsylvania inheritance tax. So the weird thing in Pennsylvania is if you have a retirement account, the rules of the Pennsylvania inheritance tax return state that if you have a retirement account, even if it's paying to your spouse as the sole beneficiary, where there'd be no tax, technically you are supposed to file an inheritance tax return. Doesn't make a lot of sense, but that is a requirement that Pennsylvania has. Okay, other tidbits we want to cover today. Transfers that you make within 1 year of death are subject to Pennsylvania inheritance tax. So let's say that my dad decided to be really generous and he wants to transfer to me $10,000. And so he transfers it to me, but then he dies within 1 year of that check being written for $10,000. What that means is that $10,000 is going to be pulled back into my dad's estate when we're calculating inheritance tax because it's considered a deathbed transfer. Any transfer within a year of death is considered a deathbed transfer. Now, Pennsylvania is really generous, and they'll take $3,000 off of that. So, and I say generous very sarcastically. So what they will do is they'll say you made a gift of $10,000, we'll take $3,000 off that. So we'll only tax $7,000 of that transfer within a year of death. So I always tell clients when they're talking about gifting to just make sure that they're keeping in mind there is a 1 year period in which that is still going to be subject to inheritance tax. The other thing that's changed in the last 5 years is that we now are able to do virtual probates. So you can actually come to our office. We have a ginormous screen, I think it's like 75 inches, that we can get the Register of Wills, the gals at the Register of Wills online, and you can be sworn in and file all the paperwork that's needed without actually having to go up to the Register of Wills. We used to have to either drive up with our client or meet them at the courthouse, go through security, all of that. Now we are not required to do that. You can come to our office and do a virtual probate. It doesn't have to be in our office. We actually did a virtual probate where we had our executor in Texas and an executor in California. So you don't physically have to be here. Date of death letter to financial institutions. So another thing that has to be done that I wanted to mention today when we're talking about death and administration is when you pass away, we need to know the date of death values of all of your assets. So one of the things that our office can do is we can send out letters to all the financial institutions to get the date of death on their letterhead. It's really helpful if there's a financial advisor because normally we can just call them up and they can provide us with a date of death letter. The executor can certainly do that, but a lot of times they want our office to do that. And the other tidbit is that I wanted to talk about if real estate is transferred for $1, but they continue to reside there. So I'll have clients come in and they say, you know, we want to sell our real estate to our son. He's going to buy it for $1. And so then it won't be subject to inheritance tax. And in Pennsylvania, unless somebody is paying adequate consideration, which means the fair market value, it is considered a gift. Even if you say it's for $1, it's considered a gift if it's less than adequate consideration. And if you transfer it, so for example, if my dad transfers the house to me and still continues to live there and doesn't pay rent, Pennsylvania is going to say, well, even though it's titled in Sam's name, we're going to pull the value back into Denny's estate and it's going to be subject to inheritance tax. So just remember that transferring for $1 doesn't work, and also transferring it to your kids and not paying rent isn't going to work because that's still going to be subject to inheritance tax. Let's talk about real and personal property and how to get rid of stuff. So we have this come up a lot with personal property. I would say that if there is a disagreement in the estate, 90% of the time it's about personal property. Sometimes it can be guns, sometimes it can be jewelry. People fight about that. So we're always trying to advise our clients to help their executor make the administration as easy and as seamless as possible. So what should you do? So you can always put it in the will. That would be a way to handle it. You can do a personal property memorandum. You can do a letter. Those would be the three ways that you can deal with specific bequests of personal property. My preference is to do a personal property memorandum. That's where you just make a list, you describe the item, who you want it to go to, you sign and date it, and that can then be kept with the will. And it's always the most recently dated memorandum. That's the one that determines how those assets are distributed. The reason I prefer that is because then if you gift it while you're living, you don't have to update your will. And if you gift it while you're living, we don't have to worry about a valuation for that asset. If we put it in the will, we have to worry about disclosing it to the state, explaining it doesn't exist in the estate anymore, or if it does, getting a value. So I always prefer a personal property memorandum. We do have a lot of clients that write a letter, which is fine too. You can do it that way. The next thing I wanted to cover is codicils versus a new will, and do you have to have an attorney draft a will? So if you handwrite your will and sign it at the bottom, that is considered a valid will. Now, it is not self-proving, which means that when you die, two people are going to have to come forward and say that is in fact your signature. So that's why most of the time people go to an attorney's office, because the attorney drafts it. And in our office, for example, I'm a witness. Typically, Amy at my office is a witness, and then we have a notary. So it's valid, it's self-proving, which means that when our client passes away, there's no additional paperwork that we have to file with the courthouse. So it can be a lot of time and trouble for your executor if you don't go through the formalities of executing a will through an attorney's office. But I always like people to know you don't have to have an attorney. You can handwrite a will and sign it at the bottom. Yes, we have had cases in Pennsylvania where people have done it with a Post-it note, where they've done a will on a Post-it note and signed it. We've also had people distribute personal property with a Post-it notice too. They might put it on like the back of a picture on certain items, who gets the item. The problem with Post-it notes is they're only as good as long as they stick on the item. So I always tell clients that's a fine way to do it until the Post-it note walks off. And then all of a sudden, these assets, we don't know how they're being distributed. That's why I like the personal property memorandum. If there's jewelry, and you're going to specifically bequeath that, we do have to get a value for that jewelry. So again, I do like the personal property memorandum. Car titles, the important thing to know is that in Pennsylvania, you do not have to probate to transfer the title of a car. Typically, you can take the title and the death certificate and you can transfer it to a spouse or to a child, no problem, without probating. However, depending on how it's titled is going to determine who can move the car or who has the ability to drive it. So if it is in the surviving spouse's name, for example, typically we only want the surviving spouse to drive it for liability reasons. So if you have a car title and you want to transfer it, I would recommend that you do that. Make sure you have it insured before you would actually start driving it. Okay, let's talk about, I know on the last slide right before the ending bullet point was talking about Papal's gift. So that's actually what we called my grandfather. I'll mention this briefly. One of the things that I like to talk to clients about is that don't forget there's a sentimental value that for certain assets. So I remember that when my grandfather got really sick, I told him and my grandmother that I wanted his glasses when he passed away. Now, his glasses were one of those big wireframe glasses and no monetary value to them, but to me, they just reminded me of Papa. So I really wanted his glasses. And it meant a lot when he passed away and my Nana actually gave me his glasses. So I always encourage people to think about that, especially when it's kids, grandkids, or any lineal descendant. You may want to leave something, and it might not have any monetary value. You might be leaving it for purely sentimental reasons, but you never know how much that's going to mean to that individual. So I would tell you to think that through too when you're talking about your will. And I do still have my Papal's glasses. I have them safely, and whenever I want to think of them, I'll pull them out. But again, no monetary, just sentimental value to this. All right, let's talk about certain wrenches that can come into play when we're talking about wills. So the first is that it could be that there's been a divorce since you executed your will or a property settlement agreement. And so we're always worried about what does that mean to the last will and testament. So just know that Pennsylvania does have a statute, and I have it noted here, that just says that you can make a modification if there are certain circumstances like divorce, marriage, or children after the will, and you don't update your will. That being said, just know it is so much easier if you have a change in circumstances, if you get married, if you get divorced, if you have children, update your will so that way we don't have to rely on Pennsylvania law and go through all of the hassle of getting that modification based on this statute. The other thing to know is that if you are planning to get married and you are doing a prenuptial agreement, one of the things that you can address in your prenuptial agreement is whether or not you're going to include your spouse as part of your estate plan or as a beneficiary on any assets. And this is especially important if it's a second marriage, because you might have children that under Pennsylvania intestate law would be entitled to receive certain assets, but you may want it to go to your spouse, or you may want to have decided before you get married how you're going to allocate it. So a prenuptial agreement can address estate planning. All right, tangible personal property. I wanted to talk a little bit about the value. So in Pennsylvania, things like household furnishings, those type of items, Pennsylvania says that you can use garage sale values. So we did one where there were a whole bunch of farm tractors, none of them were operational. And so what we did is we just went through and tried to value them based on like what the scrap metal would have brought. We just had one where there were certain items in the house. It was china, a china cupboard. We assigned a value to that as well. So just know that it's not fair market value in the sense that you always have to get it appraised. You can use garage sale values as well. I wanted to talk a little bit about the safe deposit box, because a lot of people don't realize that if you have a safe deposit box, that your executor has the right to enter it to get out the will, if that's where you keep your will stored, but they're not allowed to take anything else out of the safe deposit box. Once they get appointed as the executor, they have to notify the bank and the state prior to 7 days, at least prior to that, they're going to enter the box, and then they have to inventory it to the state of Pennsylvania. So when I tell some clients that, they then decide if they want to keep their safe deposit box, if they want to add another owner to it, or if they want to get rid of it. So I wanted to mention that. In-kind distribution. So I'm dealing with an estate right now where we have 3 kids. One kid wants to receive a portion of the real estate. So what we're doing is they're receiving less of the cash, more of the real estate. So if you leave things very vague and flexible for your executor, it gives them the ability to do that type of thing. Now, again, the downside of it being vague and more flexible is if there's a disagreement, then that can create conflict. So just think through who you're going to be appointing as the executor, who the beneficiaries are. And I would say you want to err on the side of leaving it as flexible and open-ended as you can, as long as you aren't creating conflict between any of the individuals. Think about expenses of storing, delivery, all of that. That is considered an expense of the estate unless your will provides differently. And then we already talked about how the taxes are paid from the residue or to the specific bequest. Property with no value, things like clothes. The family can get together, clean the house, they can put it in the dumpster. If it's something where they're not sure, we have a lot of great local auction houses. We're working with Hurley Auctions for one of our estates right now. They come in, they tell us what's of value, they list it, they take care of selling all of that. So I would always encourage people to consider looking at that as a possibility. All right, when we're talking about a will, let's shift a little bit and let's talk about minors. So sometimes we have younger couples or younger individuals that are coming in and doing estate planning, which is always a good thing. You always want to do your estate planning earlier. So if you're providing for minors in your estate, just know that Pennsylvania does have a standby guardianship form. That's a form where if you are leaving your children in the custody of somebody for a short period of time, maybe you're going on vacation, a weekend getaway, both you and both parents are going away, but you're not leaving with the kids with the guardian that you'd be permanently naming under the will, you might do a standby guardianship form so that that individual can take the child to receive medical treatment if needed. It just gives them, just for that short period of time, the ability to provide care for that individual. But in the will, you can name a guardian up until someone is 18. A custodial clause in Pennsylvania, that's who is in charge of the monetary assets or the real estate. That goes up into age 25 or anywhere between 18 and 25. And then we always like our will to provide the executor to be able to create a trust, an ABLE account, or a uniform transfers to minor account. That would be if you had a beneficiary that has a special need. Maybe you want to create an ABLE account or a supplemental needs trust. Give your executor the ability to do that, even if you're not actually creating that trust now, because you just never know what life is going to have for these beneficiaries, and it gives the executor the ability to account for that. Let's talk about firearms, because here where we are in Pennsylvania, we do have a lot of clients that have firearms. So the first thing is you want to make sure that the firearms can be secured, and at your death, they are secure. You want to make sure of that. You want to make sure that your beneficiary or your executor can legally possess the firearm. So there are certain classes of firearms, and depending on the class, you might have to have certain licenses in order to handle that. So you just want to make sure that you know if special requirements are required for that firearm, and B, you want to make sure your executor is equipped to be able to do that, meaning they also have the proper credentials. So you can use a reputable gun store for value, or they're really good at kind of giving you pointers about the procedures. So I had a client who actually didn't put it in their will, but wrote me a note about what gun store they typically used, because if we go back and need valuations, they can help us or direct us where we need to go. And then finally, when it comes to firearms, depending on what type of firearms and the amount, you may need to do a gun trust to hold those firearms securely under Pennsylvania law, because again, they might require a certain individual to be serving and handling those guns. Real property. Couple of things to know: if your spouse is on the deed, you don't have to redeed it when one of you passes away. That's probably the most frequently asked question we get when we're administering an estate. If husband and wife's name are on it and husband dies, wife does not need to redeed the property. It automatically goes to her. She's 100% the owner. The deed does not have to be redone unless she sells it, and then at which point we'll reference when husband died, or upon her death, that's when the deed would get done. Typically, you might want to get an appraisal, because anything that you disclose on the inheritance tax return does determine the stepped up basis for your beneficiaries. You might want to get an appraisal. You can also use the tax assessed value times the common level ratio factor. Around here, that's pretty on par with what an appraisal would be, but depending on the county that you're in Pennsylvania, that might be very low. So you just want to make sure you think through that. It's not always best to include a lower value, because if they're planning to sell the property, if you include a higher value on the inheritance tax return, it means less income tax that your beneficiaries have to pay. And the reason why is because when you die, if your real estate goes to somebody at that time, they get a stepped up basis, which just means that their basis or their equity in the property equals the fair market value on the day they die. So if they turn around and sell it, they would have zero or very minimal capital gains. If you gift the asset while you're living, your kids would get your basis in the property. So if you bought it for $100,000, but it's now worth $300,000, they would get your basis of $100,000. And then when you die, if they sell it, $300,000 fair market value minus $100,000 means there'd be $200,000 of gain that they have to pay 15% on. If they wait and receive it when you die, they would get a stepped up basis, which means there'd be zero capital gain. So I wanted to make sure to mention that. All right. If the personal representative or the executor wants to buy, then you are going to need court approval unless the will allows that. So our will always says that the executor can purchase it if that would be something they want to do. No realty transfer tax if it does go to a beneficiary with no consideration. Realty transfer tax is that really annoying tax that you pay when you buy property that typically the buyer and the seller each pay 1%. So it's a total of 2%. But if it's going through the estate and somebody's actually buying it, then there might be realty transfer tax. You can sell it on the open market. You can do it through an auction house and sell it as is if you want to do that, meaning that there's no inspections or anything with the house. That's what we're doing with one of our estates. Estates don't need the seller's disclosure form. If the personal representative is not at the closing, you might want to get a power of attorney so that you can sign the documents, meaning that our office can sign if the executor isn't physically here. And then the last tip on this slide is just including digital asset language in your will, along with the option to purchase the primary residence or real estate if you want your beneficiaries and your executor to have that ability. Okay, let's move to mediation. Talks about here. We always recommend waiving in a standard sales agreement if the personal representative is out of state. That just makes it easier. And then the personal representative wouldn't have to attend any mediation. Again, talking about as is. Let me see if there's anything else here. Oh, if you own out-of-state property, which we sometimes do have people that own, for example, in Florida or one of the Carolinas, if it's out-of-state property, it's not subject to Pennsylvania inheritance tax, but you may have to do an ancillary probate in that state unless you're titling it in a trust or with joint ownership where it avoids probate. So we always like to have that conversation too. I have a client who has property in Florida, and Florida is very expensive to probate. The filing fees are very expensive. So we're actually going to put it in trust so that way we avoid the Florida probate administration. Are you giving to a charity? So we do have some clients that are very charitably minded. So I wanted to talk a little bit about this. You can consider designating charity for your retirement. The reason why this is so important is because retirement assets are subject to inheritance tax and income tax. So if you are charitably minded and you wanted a portion of your estate to go to charity, you may want to consider designating the charity on your retirement designations so that way the asset that is taxed twice is going to charity, and the assets that would only be subject to inheritance tax are going to your beneficiaries. Know that if you wanted 10% of your gross estate, that means the whole pot. If you wanted 10% of the value to go to charity, it may mean that on your retirement plan, you're designating 25% to charity because it's 25% of whatever is in that retirement account, which then might equal the 10% of the total estate. So, and name a primary and a contingent beneficiary as well, so that way you're covered. And I just have an example here where you could name your spouse as the primary, and the contingent beneficiary would be 25% to charity and 80% to the children. Pennsylvania inheritance tax. So Pennsylvania has decided that they are going to tax beneficiaries on their right to receive assets when someone passes away. So Pennsylvania was the first state to impose an inheritance tax, and they first imposed it in 1826. And aren't we so fortunate? So states that impose an inheritance tax are Indiana, Iowa, Kentucky, Maryland, but only for certain relationships, Nebraska, New Jersey, Pennsylvania, and Tennessee. So whenever I tell clients that the ideal estate plan, because Maryland, for example, does not have an inheritance tax for direct lineal descendants, so kids. So when I tell clients the best estate plan I can tell you is retire in Pennsylvania because your retirement's not taxable, and then right before you die, move into Maryland, and then you don't have to worry about any inheritance tax. I have yet to have a client take me up on that estate plan. One of these days, though, I'm pretty sure I'm going to have somebody take me up on that. Avoiding probate is not the same as avoiding Pennsylvania inheritance tax. We talked about that, about still needing to pay tax on there. So unfortunately, unless you move out of Pennsylvania, you're still going to be subject to tax. Question that I get a lot is, my son lives in, and then fill in the state, let's just say he lives in Missouri. Does he have to pay inheritance tax? And the answer is yes, because it's based on where you lived at the time you died. So if you lived in Pennsylvania, then he's going to be subject to Pennsylvania inheritance tax. Now, again, Pennsylvania, it's always depending on the place that you resided at your death. So if you're a Pennsylvania resident, or if you have real estate that is situate in Pennsylvania, that real estate is going to be subject to inheritance tax as well. So for example, I might have a Maryland client that has a Pennsylvania property, and although the entire estate is not subject to Pennsylvania inheritance tax, that particular property would be. Same thing if I have a client that is living in Pennsylvania but has real estate in Maryland, that Maryland property is not subject to PA inheritance tax, but all of their other assets are. And I have some clients that are like, well, I have it at some financial institution that's located in Florida. It doesn't matter where the institution is located. Again, it's all about, if it's monetary assets, it's about where you live at the time. Okay, so relationship to the decedent determines the tax rate. If it's a charitable organization or government entity, they don't pay tax. If it's to a spouse, they pay tax at 0%. You're going to notice here that it is a tax. It's just at 0%. The reason I mention that is in Pennsylvania previously, spouses were taxed. They just took away that, or lowered the tax rate, but they didn't take away the tax. So that means at any point in the future, if Pennsylvania wants to tax spouses, they could do that. And then they do have property passing from a child that's 21 years or younger to a parent is also exempt. Grandparents, children, parents, adopted children, stepchildren, all of those are going to be paid at 4.5%. That's a direct lineal descendant or ancestor. So they pay at 4.5. Siblings pay at 12%. And then all other beneficiaries pay at 15%. And I will tell you, this is something that bothers me because I do have some nieces and nephews that I want to provide for as part of my estate plan, and they would have to pay at 15%. Now, what I decided to do as part of my estate plan is life insurance is exempt. So if I wanted to give them an asset where they wouldn't have to pay the tax, I could buy a life insurance policy, and then at my death, anything that paid as a result of the life insurance policy would not be subject to the inheritance tax. Okay, so what should you do now? Well, you should have an estate plan. Hopefully in this hour, I talked a lot. So in this hour that we've been talking about this, hopefully I've convinced you that you need to have an estate plan. You need to have a will, because you need to make sure that you are not subjecting your assets to Pennsylvania's estate plan that they will impose on you. Could mean you have I love you wills, which just means that you say, I want everything to go to my spouse unless they're in a nursing home, and then I don't want it to go to the nursing home. We do a lot of I love you wills that include that bypass clause in there. But again, the importance is just having a estate plan. Keep your estate plan updated. So anytime there's a major life change, you get married, you get divorced, you have a kid, somebody passes away, you want to make sure you're reaching out to our office. If there's a law change, we do try to keep track of the law changes, and we will reach out if something like that happens so that you know if you need to make any changes to your estate plan. Keep your original will in a safe place, because you do need the original will. The easiest way to probate is with the original will. You can probate a copy, but it's easier if you have the original will. So keep that in a safe place. You want to make sure you're choosing your executor carefully. So if clients will say, well, I'm just going to pick my oldest child because they're the oldest, don't do that. I think I've mentioned this before. I'm one of 4 girls. I do have a sister that's not good financially with funds. So I told my parents, please don't name her as the executor. It's not helpful for her. It doesn't protect her. It puts her at risk. There's some liability she could have as the executor. So pick the executor based on who's going to do the best job, not based on birth order or who's the oldest. And you want to make sure you're naming an executor and at least one backup. Most husband and wives name each other and then they have a backup, but you can name as many backups as you need. And a lot of times I encourage clients to name multiple backups. Keep it organized. Make sure your executor knows where the will is kept. Make sure you have an asset list, which your executor can then access. So that's why we have an intake sheet that we ask clients to fill out. A lot of it is so that when you pass away, we can provide the executors with that information. Have information available to your executor regarding the loans, credit cards, all of that, because we have to take care of all of that when you pass away. Prearranged and prepaid funeral arrangements. This is a great idea. I get clients that ask about this a lot. It's money that's set aside for your funeral or burial. So oftentimes a funeral home will give a discount if you can pay it within 30 days. And it's less stressful for family members if there are pre-existing arrangements, and it does allow you to choose the type of burial. So I'm not just talking about setting aside funds, which you can do with a specific funeral home or using an irrevocable burial CD. I'm talking about also writing things like, I want certain songs played, or I want this person to give the eulogy, or, I want these flowers. It's really helpful because then when your family's going through a highly emotional time, they don't have to be making these decisions. Okay. I can already tell that Amy and Jess are rolling their eyes because I was supposed to only talk about 30 minutes today, and I'm at 49. So I appreciate everybody being here today. Next month, so July, August, and September, we are going to do pre-recorded seminars, which means that we do have dates in mind. We're going to post it right to our website and our YouTube channel. We won't do it live. We know people are busy vacationing, all of that good stuff. So we will still have new material out, but it'll be posted directly to our YouTube channel and on our website, so you can check that out as well. I'll also have Amy send emails letting you know when we actually have released those. But you can email Amy, call her, or text her, and then we'll pick up in the fall with our live seminars again. If anybody has any topics that they want me to talk about or review again, I'm always happy to talk about them. Otherwise, it's Amy, Jess, and I trying to come up with new ideas, which we're always looking for good suggestions. Like I said, we offer initial consultations. You're always welcome to call our office. You can reach out to Amy as well. Our number is 717-655-2676. I'm Samantha with the law offices of Samantha Wolfe. I appreciate you being here. Thank you for checking out our monthly seminar. We look forward to seeing you soon.